morning. I hope you're doing well this lovely Sunday. We are going to answer a couple questions. So let's get right into it with those questions. The purpose of this live session and the purpose of this private Facebook group is for you to ask your questions and for me to be able to answer it to the best of my knowledge. But if you need a more personalized answer, you really have to consult with me. 202-751-2180. Consultation fees apply as usual. But here we're really going to try to help you because we understand that this journey is not as easy. We can make it as doable as we can because immigration takes time. And it's not as easy as you already know that, right? Because a lot of people have been here trying to get their immigration status. It's quite emotional draining. In other words, it is not easy. So we are going to be answering questions as much as we can, as possible as we can, okay? The first question is about F1 student. The F1 student said that, well, I overstayed my visa for 2 years. How can I change status? How can I apply for a waiver? Well, this question really, if I may answer this question, but what I will say before I answer this question is that this question has been answered too many times. Overstay visa, what can I do? And it really doesn't matter how you got here. In other words, F1, B1, the moment you overstay visa, you become unlawfully present. So now the question becomes, well, can I change that? Possible ways. We talked about it in the last video, really 5 easy ways to know whether you can adjust status or not. So the first question you have to ask yourself is this: do I have an approved petition? It can be family-based or employment. When we talk about family, do you have any qualifying relative that can petition for you? It can be a spouse, a parent, or a child, which the child must be 21 years old of age, and the child must be a U.S. citizen. But a parent can be a lawful permanent resident or a U.S. citizen, and the spouse can also be a lawful permanent resident or a U.S. citizen. So if you have that type of person, qualifying relative, then they could petition for you, right? Filing the form I-130, the petition for you. Once the form get approved, then you ask yourself the second question, how do I get here? In your case, F1, so lawfully enter the U.S. With the intent to study, of course, and then return, right? Dual intent, that's what they call it. But if you have a qualifying relative petitioning for you, especially if it's a spouse, then we can waive some of those unlawful presence. That's when you go to the third question, which is visa immediately available? For qualifying relatives, visa is always immediately available, except for siblings, but because they are not qualifying relatives for the purpose of waivers or for the purpose of waiving unlawful presence. So visa is immediately available. Then you go to the fourth question: am I admissible? Admissibility means that, well, at the time of adjustment, you have to be in lawful status, in lawful non-immigrant status. If you're not, then is a waiver available under your circumstances. So the waiver can only be available if you have a qualifying relative to actually waive on that person, basically claiming extreme hardship on that qualifying relative. If you don't, then the answer is you can simply not adjust status, okay? If you go to the round of employment, that's even more complicated because with employment, after overstaying the visa, you can only go outside of the US to cancel a processing. But the moment you go out, if you don't obtain a provisional unlawful presence waiver, filing the form 601A, then you're stuck there when you go out. So you have to have either a spouse or a parent in order to obtain that unlawful presence waiver, and then get out to adjust status outside of the US. And that goes self-petition cases as well. Really, you have to have a qualifying relative to waive unlawful presence. So to answer your question, if you overstay a visa and you don't have a qualifying relative, and you didn't apply for those type of asylum humanitarian petition, which is asylum, U visa, or T visa, unfortunately for you, cannot really do anything. Yeah, so right now, 2 years later, if you want to apply for asylum, really, it's gonna be too complicated because you have to prove to them why you didn't do it earlier. Those two questions, if the answer is no, then unfortunately there's nothing you can do. But you might be lucky if you become a victim. No, I'm not saying that you should become a victim, but if circumstances beyond your control make you a victim of a crime on this American soil, then you can in fact adjust status. Then you apply for U visa or T visa. I've talked about U visa, T visa on my channel. Please go ahead and refer to those previous videos. And then that's the only way you can adjust status without a qualifying valid. Second question, and I believe that's the only, we only have two questions. Find themselves in removal proceedings based on asylum. So basically asylum didn't go right with USCIS, or maybe they got here from the border. Anyway, for some reason they find themselves in removal proceedings based on asylum. Now the question becomes, can my spouse file both forms, I-130 and N-400? The answer is yes. Your spouse can file both forms concurrently. Remember, those forms go to two separate locations, and those two forms, they have two different purposes. I-130 is to establish relationship between you and your spouse, basically finding out whether the marriage is a bona fide marriage. And then N-400 is for your spouse to become a US citizen. So it's like, it's two different things. So she can file it or he can file it at the same time. It doesn't really matter because they're filing two different petitions, completely different. And then once they file it, then if I-130 get approved, then you, because you are in removal, then you can ask to adjust status before the immigration judge in court, okay? Or if the I-130 get approved, you can take advantage of prosecutorial discretion and remove your case from removal and adjust with USCIS. But remember, if you're a lawful permanent resident, the way you're going to waive unlawful presence is by filing for a unlawful, if the spouse is still a lawful permanent resident, the way to waive unlawful presence is by filing 601A and go out for consular processing. But remember that the spouse is still filing for N-400. Maybe by the time I-130 get approved, your wife or your spouse will be a US citizen, and then you don't have to leave the country for adjustment of status. I hope this question has been answered. What I can say is that yes, the spouse can file both petitions, and they are going on two different locations, okay? If your case is too complicated to be answering them here, you need to consult to 2751-2180. Consultation fees apply as usual. Happy Sunday, folks. I'll see you in my next video. Until next time, bye-bye.